Imagine America in the late 1800s, a nation bursting with innovation, industrial might, and endless ambition. But beneath the surface of this booming prosperity, something dark was brewing. Gigantic corporations, known as trusts, were swallowing up smaller businesses, dominating entire industries, and concentrating unimaginable wealth in the hands of a few powerful men. These were the titans of industry, the monopolists who believed they were beyond reproach, beyond the reach of any law. But their unchecked power would soon collide with a force they never anticipated. From oil to steel, railroads to sugar, these trusts controlled vital arteries of the American economy. They dictated prices, crushed competition, and exploited workers, leaving ordinary citizens with little choice but to pay their exorbitant demands. People watched in alarm as a handful of magnates amassed fortunes that dwarfed entire nations, while the dream of the self-made entrepreneur seemed to be fading into oblivion. This wasn't just about money. It was about the very soul of American opportunity, and the public was growing restless, demanding change. The outrage simmered, then boiled over. Farmers, small business owners, and labor unions all raised their voices, decrying the trusts as a threat to democracy itself. They saw an economic system rigged against them, where the powerful grew richer at the expense of everyone else. Politicians, sensing the shifting tide of public opinion, knew they had to act. But how do you take on forces that seemed as immutable as gravity? The answer would come from an unlikely source, a legislative proposal aimed directly at the heart of corporate behemoths. Enter Senator John Sherman of Ohio, a seasoned statesman and brother to the famous Civil War general. Sherman was no radical, but he understood the growing economic anxieties of the nation. He believed in free markets and competition, and he saw the trusts as a perversion of those very principles. For years, states had attempted to regulate these giants with little success. Their power transcended state lines. A federal solution was desperately needed, and Sherman was determined to provide it, proposing a bill that would make history. In 1890, after much debate and political maneuvering, the United States Congress passed the Sherman Antitrust Act. It was a revolutionary piece of legislation, declaring illegal every contract, combination in the form of trust or otherwise, or conspiracy, in restraint of trade or commerce. Its language was broad, almost revolutionary in its scope. The goal was clear: dismantle monopolies, promote competition, and restore fairness to the marketplace. The trustbusters' hammer had been forged, but would it truly strike down the giants?
Initially, the answer was a resounding no. The act faced immediate challenges. Its broad language, intended to be comprehensive, also made it difficult to interpret and enforce. Judges, many unfamiliar with complex economic issues, struggled to define what constituted restraint of trade. Furthermore, powerful corporations hired the best legal minds, finding loopholes and challenging every government attempt to apply the law. For years, the Sherman Act was largely a paper tiger, used more often against labor unions than against the trusts themselves. A critical turning point arrived with the Supreme Court's 1895 decision in United States versus E.C. Knight Company. This case involved the American Sugar Refining Company, which controlled over 98% of the nation's sugar production. Despite this blatant monopoly, the court ruled that the company's control over manufacturing didn't directly affect interstate commerce, therefore falling outside the Sherman Act's purview. This decision severely crippled the act, making it seem almost useless against the very trusts it was designed to target. For nearly a decade after E.C. Knight, the Sherman Act languished. The trusts continued their unchecked growth, seemingly immune to federal intervention. Public frustration mounted, and critics called the act a failure. It appeared that the promise of a more equitable economic system was an illusion, swallowed by the sheer power and legal maneuvering of industrial magnates. The hammer had been forged, but it was chipping away at minor infractions, while the true Goliaths of industry stood untouched, mocking the law. But the tide began to turn with the dawn of the new century and the emergence of a new kind of political leader. Theodore Roosevelt, a dynamic and charismatic president, ascended to power in 1901. Roosevelt was a firm believer in government regulation and famously declared his intention to use the Sherman Act to break up bad trusts that harmed the public. He was determined to wield the hammer with unprecedented force, signaling a new era for antitrust enforcement. Roosevelt's first major target was the Northern Securities Company, a massive railroad holding company created by financial titans J.P. Morgan and James J. Hill. This trust controlled nearly all railroad traffic in the Northwest, effectively eliminating competition. In 1902, Roosevelt's administration filed a lawsuit under the Sherman Act, arguing that Northern Securities was an illegal combination in restraint of trade. It was a bold move, directly challenging two of the most powerful men in America.
The case went all the way to the Supreme Court. In 1904, in a landmark decision, the court sided with the government, ordering the dissolution of the Northern Securities Company. This was a monumental victory, proving that the Sherman Act, properly enforced, could indeed dismantle even the largest and most politically connected trusts. It sent shockwaves through Wall Street and signaled to corporate America that the rules had fundamentally changed. Roosevelt had found his hammer, and he wasn't afraid to use it. Inspired by this success, Roosevelt aggressively pursued other monopolies. During his presidency, his administration initiated more than 40 antitrust lawsuits. He targeted meat packers, tobacco companies, and many other industries where consolidation had gone too far. He carefully distinguished between good trusts that operate efficiently and bad trusts that abuse their power. But his message was clear: no corporation, no matter how powerful, was above the law. The era of the unchecked industrial giant was drawing to a close. The most famous target of Roosevelt's antitrust campaign, and perhaps the most defining case for the Sherman Act, was John D. Rockefeller's Standard Oil Company. This behemoth controlled an astonishing 90% of the oil refining business in America, crushing competitors with ruthless tactics and wielding immense political influence. For decades, it seemed untouchable, a symbol of unbridled corporate power. But its days were numbered as the government prepared its most significant legal assault yet. The lawsuit against Standard Oil began in 1906 and dragged on for years. The government argued that Standard Oil's practices, including predatory pricing, secret rebates, and intimidation, constituted an illegal monopoly. Finally, in 1911, the Supreme Court delivered its momentous verdict. It declared Standard Oil an illegal monopoly and ordered its dissolution into 34 separate companies, effectively shattering Rockefeller's empire into smaller competing entities. This ruling introduced the crucial rule of reason doctrine. The court clarified that not every combination in restraint of trade was illegal. Instead, only unreasonable restraints of trade, those that actively suppressed competition, were prohibited. While this gave courts more discretion, it also provided a clearer framework for future antitrust enforcement. The breakup of Standard Oil proved the enduring power of the Sherman Act and irrevocably altered the landscape of American business.
The same year, 1911, the Supreme Court also ordered the breakup of the American Tobacco Company, another giant monopoly that had dominated its industry through anti-competitive practices. These two landmark decisions, Standard Oil and American Tobacco, solidified the Sherman Act's authority and set a powerful precedent. The message was clear: even the most formidable corporate titans were not immune to the force of federal law, and the government was prepared to enforce competition. Despite these victories, the Sherman Act still had limitations. Its language could be vague, leading to inconsistent judicial interpretations, and some argued it wasn't strong enough to prevent new forms of corporate consolidation. Recognizing these shortcomings, President Woodrow Wilson pushed for further reforms. The goal was to refine the trust-busters' hammer, making it sharper and more effective against evolving business practices. In 1914, Congress passed two crucial pieces of legislation: the Clayton Antitrust Act and the Federal Trade Commission Act. The Clayton Act prohibited specific anti-competitive practices, such as price discrimination, tying agreements, and mergers that substantially lessened competition, directly addressing some of the loopholes of the Sherman Act. It also explicitly exempted labor unions from antitrust prosecution, a significant win for organized labor. The Federal Trade Commission Act created the Federal Trade Commission, or FTC, an independent agency
tasked with preventing unfair methods of competition and unfair or deceptive acts or practices affecting commerce. The FTC was designed to be a proactive watchdog, investigating corporate activities and issuing cease and desist orders before monopolies could fully form. This marked a significant shift from reactive prosecution to preventative regulation, adding a vital new tool to the government's arsenal. Together, the Sherman, Clayton, and FTC Acts formed the bedrock of modern American antitrust law. This comprehensive framework aimed to ensure fair competition, protect consumers, and prevent the undue concentration of economic power. The vision was a dynamic marketplace where innovation and efficiency were rewarded, not squashed by monolithic corporations. It was a profound statement about the government's role in shaping the very structure of the economy.
The impact of the trust-busting era was profound and long-lasting. It reshaped the very nature of American business, fostering a more competitive environment and preventing the kind of unchecked monopolistic power seen in the Gilded Age. While debates continued about the exact scope and application of these laws, the principle was established. Government had a legitimate role in regulating the power of corporations to protect the public interest. Over the decades, antitrust law continued to evolve. Major cases in the 1940s, 60s, and 80s against companies like Alcoa, IBM, and AT&T further refined its application. While enforcement waxed and waned with different political administrations, the fundamental legal tools forged by the Sherman Act remained in place, ready to be deployed when new forms of market dominance emerged, always adapting to the changing economic realities. Today, the principles of the Sherman Antitrust Act are as relevant as ever. As new tech giants emerge, questions about monopoly power, data control, and market dominance continue to challenge regulators and policymakers. The ongoing debates about breaking up big tech echo the concerns of the Gilded Age, reminding us that the tension between corporate efficiency and competitive markets is a constant in economic history. From the railroads of the 19th century to the digital platforms of today, the Sherman Antitrust Act stands as a testament to the power of law to shape economic destiny. It was the hammer that broke the trusts, forging a path towards a more equitable and competitive capitalist system. It proved that even the most entrenched economic power can be challenged, and that the promise of a truly free market depends on constant vigilance against those who would seek to dominate it. The story of the Sherman Antitrust Act is a powerful reminder that economic freedom is not a given, it's a constant struggle. It requires active defense against forces that naturally seek consolidation and control. The legacy of this groundbreaking law continues to influence our world, shaping the competition we see, the prices we pay, and the very structure of the businesses that define our modern economy. It's a truth that echoes through every market, every innovation, every dollar spent.